All right, we're gonna go on the record. Court is calling 2024 CR 010694, State of Texas versus David McNew. Can I have parties announced for the record for the state?
It's criminal trial division.
They're not here yet, Judge. I mean, I don't mind.
Okay, I'll walk you through it. All right, for the state,
Actually, Jones for the state.
for the defense,
Carl Alexander for Mr. McNew.
and are you Mr. McNew? All right, counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor, to the best of my knowledge, the state has complied with 3914.
Court will find that the state is in compliance with discovery. Mr. McNew, did you review the document entitled Application for Community Supervision with your attorney, and did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
It appears that you're proceeding on the lesser included offense of attempted burglary of a building. Is that correct?
I'm not sure, Your Honor.
Oh, I'm reading it from the plea paperwork.
Judge, yes, yes.
All right, any objection
No,
to the
Your Honor.
lesser included?
No, Your Honor.
All right, Mr. McNew, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of attempted burglary of a building? That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bergen County Jail and up to a $4,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. McNew, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense of attempted burglary of a building. They're asking that your punishment be assessed at 1 year in the Bergen County Jail, and they're recommending community supervision. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There were pretrial motions filed, judges, but no adverse rulings.
All right. Outside the agreement, the state is requesting that your community supervision be for a term of 1 year, and there be no contact with 18321 Bulverde Road. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
And in exhibit 1 and attachments, Your Honor.
No objections, Your Honor.
All right, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to on behalf of your client?
No, Your Honor.
All right, so what is this all about? I'm assuming there's no restitution.
Correct, Your Honor.
So why is he going into someone's building?
It is an old abandoned property. In watching the body worn camera, it's been plagued by homeless encampments off and on. It's been subject to, I'll be polite and call it salvaging
Mhm.
operations. May I convey what we talked about? Sure. Okay, so what Mr. McNew had informed me about is he had been told this is a place that's abandoned and there might be things you can salvage and sell for scrap, which is what he got caught in the process of doing. He didn't realize that he's actually committing theft, which is why the state was so kind and generous in their offer. But he was very cooperative with the police, fully admitted to everything he was doing, and what items he did have or was in the process of loading remained there at the property.
All right, does he have criminal history?
He does.
He does.
All right, and what is the criminal history?
He is an addict in recovery, so I'll tell you there is possession charges in his recent past.
May I approach, Judge?
Yes. All right, we can go off the record. All right, this is the reason why I was asking these questions. Because if everyone agrees and state, I do understand you're going on the lesser included offense because of the fact that he was told that it was abandoned property and that you could come there and salvage. And it appears that there was no locks that were picked or anything.
Correct, Your Honor. There's open access through there's a wall around the property, but it was fully open.
So here's my question. Is this really, it's a conviction on his record. I'm assuming the state agrees that he thought it was salvage and people were telling him, hey, you can just come here, grab something and sell it. Is this really a probation case? Wouldn't this, he has the conviction. Do y'all want to consider just a time offer?
The issue with that, Judge, is Mr. McNew is the caregiver for his 44-year-old son who suffered a traumatic brain injury.
Just a moment. Satisfied?
I think the only credit that he has is 1 day. I'm fine with it.
All right.
2 days, even worse.
Okay. So,
Yes, ma'am. Absolutely.
all right. So the plea bargain, then are all parties agreed for 2 days in the Bear County Jail?
State agrees.
Defense agrees, Your Honor.
All right. Any objection to the court changing the plea paperwork?
Absolutely not.
All right. But this is what the court will do then. As previously stated, the court is finding there's sufficient evidence to find you guilty. The court is going to find you guilty. The court will sentence you to 2 days in the Bergen County Jail. Give you credit for any time served. There still is to be no contact with 18321 Verde Road. And the court will find that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, state. And because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. There is no pirates or anything that's happening. If there is a place that appears to be abandoned, run a search on the place. Call the police, ask. You understand? All right, good luck, and I hope you continue to maintain your sobriety. All right, have a great day.
Thank you, Judge. May we be excused?
Yes.
Okay.
Oh, excuse me, Carl,
Yes, sir.
make sure that they don't need to print him or anything.
Oh.
Yeah.
Oh.
It's just the elevator, we have an issue with the elevator. You don't have to pull that out. I'm waiting for.
Yeah.
Where's our-
Is there a judgment? There's no one custody issues. David. Wait.
Oh, and Carl.
Yes, Judge.
If y'all will just change the plea paperwork so it can reflect that there's no application or any of
Okay.
that. And just have him initial that.
Initial.
And then if you'll turn it into the clerk.
Okay, good.
Thank you. All right,
On straight. First row, second row, and five.
let's hear William Richardson.
Judge, that's the one that was, transferred to the 399.
Okay, thank you. All right, and Mr. Charis, are you ready to proceed? Okay. Okay. All right, well, I mean, if you want to confer with them or either.
I was just checking on the second witness.
Okay.
I call my client up.
Sure. Ms. Nutter, if you'll come back up, please. And Jason, on this one, you all are opposed.
Yes.
Okay. And it's burglary of a habitation. And cap of 5. All right. All right, we're back on the record in 2024 CR 011162, State versus Nicole Nutter. If I could have parties reannounced for the record, State. Defense.
Albert Chidas from Miss Nutter.
And are you Miss Nutter?
Yes, ma'am.
All right. So State, you said that you had another witness present.
Yeah, one other person I was gonna call.
All right, if you call them, please.
Paige Slater.
All right, hello. Hi, and excuse me, you need to stand over there. If you'll raise your right hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Paige Slater.
All right, if you'll make sure you keep your voice up so that I can hear, because my allergies are acting up, and also so that the court reporter can hear.
Yes,
All right, defense.
Could you let me know what your relationship is to Miss Nutter?
she's my mom.
And where do you live? Not address, but town?
San Antonio.
Okay. And are you willing to help your mom get through, assuming that court were to give her probation? Are you willing to assist her in housing?
Yes, she can stay with me on that.
And do you live alone in the apartment? Do you have children in the apartment?
No, just me and a dog.
Okay. And are you aware of your mom's mental health issues?
Yes, yeah, I grew up with her.
And so are you willing to help her to try and stay on her medication so she can maintain a healthy mental state?
Yes, yes, and 100%.
And are you employed?
Yes, I'm self-employed.
Okay, all right. I have no further questions, Judge.
All right, any questions from the state?
No question.
All right, and just one for me.
I'm
Out of
sorry?
curiosity, what do you do?
Social media.
Okay. All right, so what, when you say social media, what are you?
Yeah, like basically influencer, like I make probably like 10 to 20.
Okay, all right, thank you. Okay, all right, thank you so much.
Thank you. And I have no other witnesses, Judge.
All right,
Just
so,
argument.
all right, I'll hear your argument. Oh, you can come back up.
So Judge, I know Miss Nutter did have some issues with her probation in the past. She's had probation before. But she's always, had the issue with being bipolar. That's never gonna go away, and that's something where it's been a struggle for her. It's also cost her to do some things that are erratic. She's gotten into drugs. It seems like she's overcome the issue of drugs, but she's still been struggling with her mental health. And she did have a job before she was arrested. She was working with I'll probably butcher his name, but Tim Height, the complainant. And Tim was very generous, very helpful. He's a religious man, and he was helping her in giving her a job, giving her a place to stay, trying to get her, closer to God and away from drugs. He was interviewed by the state, and he himself feels that it's way too much to say it was a burglary of a habitation. He thinks that it probably should have been like a criminal trespass. He just wanted her gone because she was acting so crazy, so erratic, out of control. I think in page 5 of the report to the court, he's interviewed and kind of gives his thoughts on the matter, which is that he wants her to get the help she needs. He thinks she has a drug problem. But she is bipolar and she wasn't on her medication, so either or. She either has to be getting her medication for bipolar, and in addition, if there's a drug issue, getting drug treatment. And my client's open to doing what she needs to do. She's just asking the court to have the opportunity to do that. She does have a place to go back to. Her daughter will let her stay with her, and I think that it's probably a better solution than putting her in TDC and at taxpayers' expense, when she can kind of try and get her affairs in order and still abide by the court's requirements. And if she doesn't, the court always has the opportunity to simply revoke her if she doesn't do what she's supposed to be doing. So-
State.
So for that reason, I would just say, I'm sorry. Yeah,
Okay.
for that reason, I would just say if you could give her probation. Thank
All
you.
right. Thank you. State.
Jeff, just to the previous history of repeat offending states in position that in lieu of prison, we have a long probation, we approach it a case.
All right. So I will tell you, this is a very difficult case for me on deciding what to do because I don't have a crystal ball. So I'm weighing the fact that you never successfully completed probation. I mean, the PSI I'm reviewing you're given probation and each time you were revoked. You were revoked in 2008. And that was interference with child custody, and I'm assuming that's involving the 13-year-old.
That's involving this young lady
Oh,
that,
that's involving her, okay. And then there was the bail jumping in 2013. And I know depending on what county you're in, when you don't show up, they'll charge you with bail jumping. And then the probation on that was revoked. And then everything else, it appears that you have taken time. So this is a difficult case. And then the complainant, I've read the PSI report, the complainant does not want you to go to prison. Complainant feels that you need help, that you have mental health issues and drug issues. Now, according to the TAP evaluation, they think that you're minimizing. So this is what I can tell you I will do. And at first I was strongly thinking about giving you 3 years in the prison and not granting your application. But if I grant your application for probation, you're going to remain in custody because they want to evaluate you for DDRF. And how long is DDRF?
It's 120 to 180 days. Currently, there's a 10 to 12 week wait for females.
And I have no choice but DDRF for you because it appears that you have the mental health issues along with drug issues. I could refer you to felony drug court, but if felony drug court doesn't accept you, then it would be DDRF. So you can either, I can sentence you to 3 years in the prison. You'll receive credit for whatever time you've been in. Or I'll grant your application. People will tell you probation in here is not easy. It's designed for the probationer that's before me. But if I grant you probation, then you're going to remain in custody. She's told you what the wait time is. That's the wait time. I have no control over that. So those are your two choices. If you would like to discuss it with your attorney, you can. All right. You're welcome. Y'all want to sit in the box and discuss? And then I'll bring you all back up. All right,
well, Judge, actually, she's pretty clear on what she wants to do.
yes.
That's fine with the waiting in jail, doing 180 days in jail.
All right, no, she's saying it's going to be 180 days. And then what else, Ms. Abrams?
So the program itself is 120 to 180 days. And the wait time is 10 to 12 weeks. That's after medical. Medical can take anywhere from 2 to 4 weeks.
So you're looking at the time in DDRF plus the wait time. You want to think about it a little bit? Sure. Okay, all right, just let me know when you're ready.
Yes.
Welcome. If I had the ability to put people in programs sooner, I would.
Yeah. Don't talk to him.
Okay, so family members, let me explain something to you guys. It's their choice, what they want to do. I would always tell my clients this. When the family members would tell them do A, B, C, or D, I always say, you know what? At the end of the day, if that person ends up going to prison, you're not doing the time. If that person ends up accepting probation, you're not the one who's on probation. They are. So it has to be their decision. All right? So if you all try to speak to her again, you're going to be removed from the courtroom. No problem. Who's here on settle?
I am, Judge.
Yes.
She's in the back.
Downstairs.
Okay.
Oh, okay.
Yeah.
We have a bond reduction motion, Judge.
Okay, so I need her out. All right. So whenever she comes out, just let me know.
Thank you, Judge.
Oscar Barrera. All right. So on this case, where are we on discovery?
We are good on discovery. Your Honor, the state has made a plea offer that I'm 95% certain that we're going to take, but I'm asking for a short reset.
All right, Ms. Ferguson, can I have a 2-week reset for a plea deadline date on Barrera? Is that enough time?
Can we get 30 days?
No.
Okay.
All right, what date did you say? All right, so we're gonna come back on February 20th. On February 20th, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, then your next setting will be a jury trial. All right, thank you.
Thank you.
Once you sign the reset form, you're excused, okay?
Thank you.
You're welcome. All right, if you have a come back up. What page was Barrera on? Thank you. Yes, we're back on the record and 2024 CR 011162. All right, have you all had a chance to discuss your options?
We did, Judge.
And what are you requesting, Ms. Nutter?
3 years,
Prison?
yes.
All right, the court is finding you guilty. The court will sentence you to 3 years in the prison, give you credit for any time served. I'll request the therapeutic community for her. But you'll have to request it also. Do you understand?
No.
When you go there, you have to let them know that you would like to be in the therapeutic community. The therapeutic community doesn't increase the time that you're in the prison. It's just designed to help you, for example, for you with your mental health issues and any drug issues, okay? And there is a $2,000 fine, time and money to run concurrent. And there's to be no contact with Timothy Height, Haight, and Country, Kountry, Campground RV Park. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and did you sign it?
yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your
All right, so we can go off the record. Here's the thing. At some point, you're going to be looking at a habitual offender status. And what that means is for certain felonies, if you're charged with it, your minimum is 25 years in the prison. You understand?
Yes, ma'am.
So you're going to have to do better. You're going to have to stay on your medications. When you're released from prison, if you can't find a place that can help you, you can always come back to the court. If I'm still here, I'll see if I can help you find a place. All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, that's it.
Thank you, Your Honor.
Thank you.
Have a seat, ma'am.
All right, are you all ready on Jordan Davis?
Yes, Judge, present.
Did I see that file? Okay. I'm so sorry. It never was removed from yesterday. All right. Court is calling 2024 CR 5244 State versus Jordan Davis. Do I have parties announced for the record for the state? Defense?
Good afternoon, Judge Alfonso Cabañas for Mr. Jordan Davis.
And are you Mr. Davis? All right, you all had a bench trial with the court, and the court, after both parties had rested and closed, the court asked for an opportunity to view State's Exhibit 1 in its entirety. The court did have a chance to review State's Exhibit 1 in its entirety, so the court will hear closing arguments. State?
Your Honor, does the state typically not give closing arguments in trial following the defense?
If they want to. My understanding from speaking with you off the record that the defense didn't really want to do a closing. So that's why I was asking you for your closing.
Your
But
Honor,
if that's,
I don't know whether defense counsel wanted to or not. But
all right,
my
defense, do you want to get closing?
Yes, Your Honor.
Okay, then I'll hear your closing.
Thank you, Judge. Judge, as the court was aware during cross-examination a couple of days ago, the only officer that stopped Mr. Davis testified that the alleged offense, the alleged traffic offense, excuse me, that he saw being committed was not recorded. I asked him about, rather, when I talked and described as to the reason for the stop, he initially said, well, his headlamps were turned off, or he didn't have the number of requisite headlamps as per the transportation code. When he confirmed on the stand that as per the transportation code, my client had more than two, he had three functioning headlamps, so much so that during the video, if the court recalls, the officer testifies that the headlamps in my client's car were working. Therefore, Judge, we have testimony from the officer that the alleged traffic offense of not having any functioning headlights is completely false. Secondly, Judge, after we move on from that point, the officer goes on a narrative in which he's trying to tell the court what he, the officer, would do in this situation. The transportation code and the penal code don't read that way. The transportation code and the penal code read that my client or the individual who is alleged to have been committing an evading offense needs to be clearly shown as evading law enforcement. If the court recalls from the video, during the entire length of the officer following my client doesn't speed, doesn't turn off his lights, does not drive in excess of the speed limit, does not drive under the speed limit, does not avoid traffic, does not flee from the officer. Additionally, my client goes so much as to take the extra step and notify the officer by turning on his hazard lights. The officer makes it a point to say that there were multiple shopping locations or shopping centers on the left side of the highway in which my client could have turned. Well, Judge, then I questioned the officer on Texas DPS, the driving manual, which states that when being followed by law enforcement, a driver has to stop, or rather must go to the right and stop in a place that's well lit and safe, not only for himself, but law enforcement behind him. So when I questioned the officer as to whether or not my client could have stopped on the right, being that it's a construction zone, being that there was nothing but grass and dirt and it was not lit, the officer said, well, I don't know, but I could have stopped there. As we proceed through the stop, or through the video, Your Honor, again, you continue to see that at no point in time did my client commit any additional traffic offenses other than the alleged traffic offense, which again was not recorded. The officer testified that my client was driving a vehicle that was not stolen. He was driving a vehicle with a seatbelt on. There was nothing that my client was doing as he was driving that warranted a traffic stop. As the officer continues to follow my client with his hazard lights turns to the right as he should, and then parks in an area where the officer testified there's no cars coming back and forth, thereby making it safe for my client and law enforcement to continue this interaction. And so the point of this, Your Honor, is that at no point in time did my client evade any arrest or detention. My client simply drove to find a place to stop. We know that he did not flee. We know that he didn't even intend to evade arrest or detention. He was simply looking for a safe place to stop. And as he was doing so, he notified the officer behind him by turning his hazard lights and maintaining a safe rate of speed. And for those reasons, Your Honor, I ask the court to find my client not guilty of the offense of evading arrest or detention.
All right. State.
Defense counsel's arguments are well made, but at certain points logically inconsistent and at other points irrelevant. Mr. Cabañas points out that the deputy's testimony was that Mr. Davis had 3 headlights on. Now, if Mr. Cabañas means this to mean that the high beams were on, then Mr. Davis committed an offense by having his high beams on within 300 feet of oncoming traffic. In which case, Mr. Davis committed an offense of the transportation code.
Was there oncoming traffic?
There was, Your Honor. And
Okay.
we'll be able to see it from the officer's dash cam recording. So Deputy Enriquez did have reasonable suspicion to detain the vehicle. Moreover, case law is clear. Under Lopez v. State, the Court of Appeals for San Antonio stated that although the officers agreed that Lopez was not accelerating from them or driving recklessly after exiting the highway, fleeing is anything less than prompt compliance with an officer's direction to stop, and fleeing slowly is still fleeing. So the fact that Mr. Davis did not speed or travel under the speed limit, the fact that he did not weave in and out of traffic, the fact that he was wearing his seatbelt, these are all very interesting assertions, but they are not relevant to the court's determination of whether he evaded arrest or detention. Finally, there's been no evidence introduced that Mr. Davis was actually following the Texas DPS handbook. There's been no evidence introduced that he's ever read it. There's been no evidence introduced that he was even vaguely aware of it. And so Mr. Cabañas' reliance on this Texas DPS handbook is misplaced because there's no evidence that Mr. Davis was actually following its advice. Even if he were, there were multiple areas for Mr. Davis to stop. The area in which he stopped was not a well-lit place. Deputy Enriquez testified that after the vehicle came to a stop, other vehicles had to go around it. And it's because where Mr. Davis stopped was on a 2-lane road with no bike lane or improved shoulder for him to move into. And so the only place that he could stop was in the lane. So for those reasons, the court should find him guilty.
All right, so you're saying that there is no proof that he knew what was in the Texas driver's handbook, and therefore that should be disregarded? The officer's testimony on the, with regards to the Texas driver's handbook?
The officer's testimony is not evidence that Mr. Davis.
No, that's what I'm saying. You're saying that there's no evidence that he knew about the rules for the Texas driver's handbook.
Correct.
And how is that relevant? Because does the defense doesn't have to present any evidence, correct?
Correct. The defense does not need to present any evidence. But if the defense wants to rely on this DPS handbook for the proposition that Mr. Davis was obeying its advice, then there should be some evidence that he was at least aware of it, much less that he read it and that he obeyed it. And there's been no evidence.
All right. All right, the court has reviewed State's Exhibit number 1 in its entirety. I've heard both parties' argument. As both parties are aware, argument is not testimony, it's not the law, it's just your argument. After reviewing everything, listening to the testimony and seeing State's Exhibit number 1, the court will find the defendant not guilty. Is there anything else from either side?
Not from defense counsel.
Okay, thank you. If you will give this to the court reporter, please.
Yes, Your Honor.
Thank you for dressing appropriately for court.
Thank you, Your Honor. That's-
They would be excused, Your Honor.
Yes. Oh, and can I have the? Oh, here's the order. Oh, could I have? Did I give you Davis?
Make it sure you're not-
Okay, why does this have? Is it something like this or that? Oh, he entered the plea tonight. There's something. Let's see, this is for, and it says January 31st, so let me see what's going on. All right, this one's done. Okay. Christopher Rivera. Christopher Quinn Rivera. Lorenzo Garcia. Where's your attorney? All right, we'll come back with that. Nicholas Lee Cameron.
Judge, that's the one where, Lindsay's in trial. Yeah. He's in the box, Judge.
All right. All right, Mr. Cameron, if you'll come down, please. Nicholas Lee Cameron. Are you Nicholas Cameron?
First person.
All right. I don't have Christopher Cameron up here. I have Christopher Rivera, and then I have Nicholas Lee Cameron and Lorenzo Garcia. Could I see the file on Christopher Cameron?
Matthew Brown is my, yeah.
Oh.
Dave Cameron is actually Christopher Cameron's brother. Make that more confusing.
All right. All right, well, just have a seat. We're waiting for your file then. Is there anybody else who's ready? Who do you have?
Mr. Bergen.
All right, could you pull that file, please?
This is an NTR, Your Honor, but we're going to be requesting a bond decision.
Okay, where's your client?
He is in the box.
All right, come down, please. All right, counsel, on this case, did you file a motion?
Yes.
All right, Norma, could you pull the motion for a bond?
Yes, ma'am.
I've actually got a copy right here.
We have a copy.
How about that?
So have you had a chance to discuss this with the state?
Yes, I have, Your Honor.
And do you all have an agreement?
Yes, we do, Your Honor.
Okay. All right, court is calling 2023 CR 10637 State versus Mr. Bergen Savala. Could I have parties announced for the record for the state?
Andrew Harris, Edelman.
Ron Zimmerman for the defense.
And are you Mr. Bergen Savala?
Yes, Your
How
Honor.
do you pronounce your first name?
G.
Ranji?
Yes, ma'am.
Okay. All right, you have a motion to revoke and it's deferred adjudication. The defense is requesting a bond. You're entitled to a bond. Have parties agreed on a bond?
Have your own.
And what amount is that?
That would be $7,500, Your Honor.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record.
Bergen Savala.
All right, Mr. Bergen Savala, I'm not going to ask you any questions about your motion to revoke or any questions about the case. The only thing I'm going to ask you questions about is so that I can determine whatever conditions will be appropriate for your bond. All right, so have you ever been diagnosed with any mental health issues? Ever been on any type of medications for any mental health issues?
No, Your Honor.
In the past, have you ever used any type of drugs? All right, and what would that be?
Marijuana.
And what else?
That's it.
All right. Any alleged gang affiliation? And if you were released on bond, where would you be? Well, who would you be staying with?
My mother and my sister.
And how old is your sister?
I have three of them. 21, 20, 21, 19, and 17.
Are there any children that are underage in the home?
Yes, my 21-year-old and 19-year-old have sisters. They each have a son apiece,
All right, and what is the child's age?
2 and 1.
Any concerns about him living in a location with children state? All right, then I'll follow your agreement. I'm gonna set your bond at $7,500. There's to be regular UAs. And Ms. Ferguson, if you can set this in 2 weeks for a contested hearing, please. All right, you coming back on February 24th for a contested hearing? And if you'll make sure he has a reset form. All right, do you have any other questions? Anything else? Yes. Yes.
Mr. Bergen Savala has an unindicted PG 1 4 to 200, for
Mhm.
which Meredith Chacon is the attorney of record. Would you please set that case on the same date so that we might try to resolve both cases simultaneously?
All right, Ms. Ferguson, if you'll set those both. All right, anything else?
Yes, Your Honor. I'm wondering if it might be more efficient for Ms. Chacon to be the attorney of record on the MTR as well, too, Your Honor.
I don't think so, because, and the reason why I say that, because she's not here. And I've
Yeah.
given you all a contested date and I want everybody to be ready on that date.
Okay,
All right, thank you.
all right, thank you, Your Honor.
Thank you. And what page is he on? Thank you. All right, can I see the file on Shayna Jessame, please? Deputy Laura, could you make an announcement for Shiana Nicole Jessame in the hallway? And Norma, can you see where the attorney is? Can I see could you have somebody from MAC come down, please? And could I see the file on Ruben Maldonado, please? All right, Mr. Maldonado, just have a seat. We're gonna see, have you had any contact with your attorney? All right, we'll have somebody from MAC come down, okay? Thank you. Deputy Laura? No? Okay, thank you. All right, who's here on Elon Gonzalez? Where's Dan McLean? All right, Mr. McLean, are you ready on Elion Gonzalez? Elon Gonzalez.
Yes.
Can I see the file on Elon Gonzalez, please? Where's Elon Gonzalez? Come down. Sometimes I add too many syllables to a name.
Judge, do I have an Elon Gonzalez?
Yes.
I have a Lorenzo Garcia.
All right.
Hey, you know, I had it.
Hello, this is your attorney. Sometimes.
I know that I had,
Yes.
I had it on my schedule. I didn't get notice. of a
All
second
right,
today.
so sometimes attorneys don't receive notice because Odyssey is pretty weird. So I give them some leeway when it's the first appearance. So this is your first appearance with this attorney being present and on the docket. So it's a possession less than a gram. I don't know if you want to confer with the state council.
I do. And can I get the cause number on that, Judge, just so I've got it?
It's 2024 CR 011619.
Thank you, Judge.
All right, so
I'll
he's
pull
going to
that file
confirm with
and
the state, okay?
confirm.
All right,
Thank
thank
you,
you. They're gonna confer. Leo Kantu. Where's Will Brooks?
He went to Veterans Court. Judge, he'll be right back.
Okay.
His client's not here.
All right. He's in custody. All right, can you?
And another one.
All right. So as soon as they're brought up, then you can give that to me. I'm just trying to work my way through the docket. Yes. It's Will Brooks' client.
He said that he will be here for a few.
So he said as soon as you bring him up, he'll run upstairs. Yep, good.
Deputy Laura.
Can you bring us? Or no, you just want to come over? Okay.
Deputy Laura, here you are. Oh, you have it? Okay.
Oh, yeah.
Jason, and I'm sorry, if I could see you all in the hallway. Yes. Yes, please.
That's me, sir. Upstairs.
And Miss Abrams, could I see you, please?
Okay, Pete. No. I'm telling you, how many people down there and I'm fighting, they were saying you need to stop. So you have to be there, you have to get some people back. No, you put, and there's some hole, you just put. Oh my God, I can't read. Then you have to be more patient.
Ready. Thank you. Okay, for income cooperative.
Yes.
What's the other case then, BTRC?
It's not, they're gonna reject it, so I was just gonna
Oh,
look to the state right now, see if they're gonna put that on there.
thank you.
Thank you.
Who's the attorney?
I never even met her.
All right, so we're just waiting for Matt, correct? Yes. All right, so what cases do you have?
Lorenzo Garcia. And it's a DW on third. We just need to do a quick reset so I can do my blood discovery.
Lorenzo Garcia?
Lorenzo Garcia.
All right, Lorenzo Garcia.
That was not.
All right, so on this case, where are we on discovery?
Judge, it's the first setting on this. I need to do just some blood discovery. I reviewed the file. Andrew's, I believe, making me an offer on that. We're gonna try and see where we are with that. But I need to do at least some due diligence just to kind of make sure that everything was done the way it was supposed to be done.
All right, Ms. Ferguson, can I have a 45-day reset? And I'm gonna give you 45 days because of the blood discovery.
Thank you, Judge.
All right. All right, so we'll be back on March 24th. Council, does that work with your schedule? Because I know you have.
That's a Monday.
That'd be
Okay,
perfect, Judge.
all right. So once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're
Thank you,
welcome.
Your Honor.
And who else do you have?
The other one was Robert Castillo.
All right, let me see if I can pull that. Just one second.
Yeah.
Sorry, Robert Castillo?
Yes, sir.
And have you conferred with the state on the motions?
I did. Megan and I were talking earlier. It appears we've got two motions. One's to inspect and appoint an expert.
Mhm.
It's an Icky motion essentially. And then and that is to appoint Greg Pratt as an expert, as an investigator. We talked earlier, the other motion was to withdraw the search warrant. That's already been executed. That report from the Tesla is actually already at the lab. What we're trying to do is ascertain whether or not those holes are bullet holes and whether or not we're gonna be able to recover slugs from the vehicle. That's why we need Mr. Pratt. Talking with the state, if they come back and say that those are bullet holes, it may render that moot. The problem I've got is with state too, correct me if I'm wrong, if I'm inserting words in your mouth, we don't know when that's gonna get back, and we've got a March 4th trial date. I think it's trial date, or is it a final consult?
It's a plea deadline date and jury trial date.
Plea deadline date and jury trial date. So I think where we're at, this would obviously fall under 3914 as exculpatory if it does indeed come back as bullet holes. I don't know that we're gonna be able to get that 20 days before.
Oh, I think we can if people work, if the people at the lab work.
Yeah, and Judge, let me just, so, because I know you do your discovery settings and obviously you're aware that I wasn't in this court, but upon being appointed to the case, I did, look at the evidence and determine based on what, Mr. McLean is asserting that I needed to go ahead and take an extra step, to determine what was really going on at that time. And so that's why I had the detective go back out there to pull the bumper and send it. So I have spoken with the people at the lab to try to get them to expedite the testing. And that's all I can do at this point, but I don't want the court to think that I was doing it for purposes of delay.
Oh, no, I don't think that. Sometimes discovery is not in the hands. Technically, it's not physically in the hands of the state. It's in the hands of some third party. So is your client here?
Yes.
All right, have him come up.
And also it was something that wasn't investigated at the time of the offense. So once I was made aware that Mr. McLean was making this assertion, that's when I went ahead and decided to take that extra step.
All right, Ms. Ferguson. On this case, recall this back for the week of the 17th and wherever the evidence is located and whoever the expert is in charge of looking at it, they need to be available by Zoom. And counsel, I'm not looking for a cross-examination. It's just to get timelines from them of when they think things will be done. And also where you'll know where things are so your expert can view it.
And that was my only other request, Judge, in that motion to set aside the warrant. We did plead in the alternative that if it had already been executed, that our expert would have access to it, which I know is probably difficult if it's over at the lab. And so.
All right, so what we'll do is, Ms. Ferguson. All right, counsel, we can set this Tuesday or Thursday. Monday is a holiday.
Let's, Monday the 17th is a holiday.
Yeah, President's Day.
Oh, for February. My bad, Judge.
Mhm.
I thought we were in March. Let me look up here. 17th.
State, I
Let's
figured that
do,
would
let's
give
do
you a
that
week to get
Tuesday,
them.
because that's my whole mental health thing gets shifted. So Tuesday works.
All right, Ms. Ferguson, if you recall this for Tuesday, and it's for discovery, and your witness can appear by Zoom, and the whole person is not a fishing expedition per se. It's just to figure out what's the timeline when they will have thing done, and so that you'll know who it is, so that there can be a contact with your expert in case your expert needs to go and see something. And then at that time, counsel, I'll make a ruling on your motions. And of course, I'll grant your motion for an expert, but if you can have the court, give the court some sort of idea of what you think the amount will be, because it's not in the motion.
I'll talk to Mr. Pratt and find out what he's going to require, and I'll approach the court. Absolutely.
All right.
Does Mr. Castillo need to be present on this?
He needs to be present, but he can be present by Zoom.
Thank you, Judge. That'd be
Yes.
great. Thank you so much.
All right, thank you. Once you sign the reset form, you are excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome. And Norma, they can appear by Zoom. Thank you.
And so,
It might change, but that's.
Oh, it'll be the same. All right, who's here for Leo Antonio Cantu?
I am. He is downstairs and I apologize. I did not have him calendared today.
Okay.
I'm double booked. I'm in the middle of Veterans Treatment Court docket.
Okay.
And so if the court would allow me to. Maybe. I was gonna ask if the court could recall us to Tuesday so I can finish that.
Leo Cantu? Come forward, please. All right. Hello, Mr. Cantu. All right. How are you doing today?
Great, thank you.
All right. So this is what I want to let you know. This is your attorney. Sometimes attorneys do not have clients on their docket. There are some things they switched over to the new system of Odyssey. So your attorney actually didn't have notice for this hearing today. He just happened to be here on another matter. So we're going to recall you back for February 18th. So that'll be on a Tuesday. And your attorney is now aware that you are one of his clients. So I'm sure he'll speak with you before then.
Awesome. Thank
All
you
right.
very much.
Thank you. Yes. February, I'm sorry, Counselor, did you want February 18th or February 11th?
If I could do the 11th, that would be great.
Okay, I'm sorry, February 11th.
Thank you, Mom.
You're welcome.
Oh, so you got us the whole thing, all right?
The judge,
Yes.
that was accidentally taken back to the jail, but we request her back.
Okay, thank you.
We don't know.
I was gonna ask for the same.
Let me, we can do it on the 11th or either if they can do her by Zoom. Whatever you wish, counsel.
11th would be great, Judge.
All right, we'll do it on the 11th.
She got a default bond reduction by virtue of the fact that one of her cases was dismissed today.
Okay,
Thank you, Judge.
you're welcome. Could I see, do I have the files unsettled? I may have it up here, yeah, yeah, it's been one of those days.
She finally said it. She finally.
Do you guys have bingo on me? Where's Kiki Palmer when you need her? I'm telling you, that was a great movie, though. All right, thank you. Hello. See if you could send a rejection for me. Oh, sure, just give me one moment. I'm sorry. Okay. All right, that's. And what do you have?
I just have rejection.
Oh, that didn't pop up. Just one second. 6217. All right, thank you.
Thank you, Judge.
All right, Nicholas Cameron, Christopher Rivera. We're still waiting for them. No, I have you as Christopher. Well, I have someone by the name of Christopher Rivera and someone named Nicholas Lee Cameron. Okay.
Did you give them? Camera.
Oh, sir, just have a seat. And who's the attorney on Christopher Rivera?
That is, Charles Gold.
All right, and what is happening with Mr. Gold?
It's just, it was set for today, but his other two cases were set on the 20th.
Okay, all right, thank you.
It was my fault. Because I didn't sit up.
No problem. All right, Giovanna Moore. Are there any applications?
No.
Court is calling 2024 CR 0572, State of Texas versus Javon Allen Amore. Could I have parties announced for the state?
Ashley Jones.
Defense.
Peter Calderola, standing in for Gail Calderola for Mr. Moore, Your Honor.
And are you Mr. Amore?
Yes, ma'am.
All right, do you have any objections to this attorney standing in? All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find the state is in compliance with discovery. Mr. Amore, did you review the true bill of indictment with your attorney? Did you understand it?
I have, Your Honor. Yes, I understand.
Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
State, are you proceeding on the indictment as presented?
Yes, sir.
All right, Mr. Moore, did you review the document entitled?
We did an indictment to correct the date, the year. And
Thank you, Judge.
paragraph 2023.
All right, any objection to the state
No objection, Your Honor.
amending the indictment or correcting the indictment?
None, Judge.
All right, Mr. Moore, do you understand that's a substantive change to the indictment?
I understand.
And knowing that, do you still wish to proceed?
I understand.
And do you waive the time your counsel has to prepare for trial? Your counsel has 10 days to prepare for
Oh, yes.
trial. Are you waiving that?
Yes,
Do you wish to proceed?
yes, yes.
All right. Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with assault family household member with a previous conviction as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge. Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 4 years in the prison. There's a $1,500 fine and no applications. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor, I understand.
Knowing that, do you still, I'm sorry, do you understand that to be the entirety of your plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I have signed an order in corporation, Your Honor.
Did you understand by signing that you're waiving your right to only items that can be appealed or written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
None, Judge, none that I'm aware of.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor, state other states in one and all.
No objections, Your Honor.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you asking to proceed with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Whenever the court's ready.
I'm ready.
Thank you, Judge. Your Honor, respectfully, today we'd be requesting 2 years TDC for Mr. Moore. He's been in custody for approximately 418 days. I believe the docket reflects 412, but I understand it was printed several days ago. He's a 36-year-old man, Judge, and he has been with the complainant, Miss Capricia Morris, for approximately 9 years, Judge. Ms. Morris does have 4 children, and Mr. Moore has stepped in as a father for those children. Now, he does not have any paternal rights, but he has helped raise those kids for the last 9 years. Ms. Morris has actually contacted our office as well as my client's mother, requesting that Mr. Moore be home. Mr. Moore is motivated and will be dedicated to finding a job so he can get back to supporting those children. And Ms. Morris as well, Judge. And that's the reason we're asking for the 2 years today, as opposed to anything beyond that.
All right, and what is happening with this violation of bond or protective order?
Your Honor, our understanding is that the complainant does not want to proceed, so the state will be dismissing the
All right. And then state, what are you requesting?
Your Honor, the state is requesting 4 years, the 4 years that's corrections. That does have several arrests for assaults. Unfortunately, those were dismissed for missing witness, but this does seem to be a pattern with this defendant. Additionally, as the court can see here, there are 2 cases in front of the court for assault on the same complainant that the defendant does want to go back to. Sometimes, even though the complainant does not want to proceed, it is the state's job to look out for the safety of that complainant and the safety of our community. So for those reasons, the state is asking the defendant to be sentenced to 4 years.
All right, is there anything you wish to say, sir?
I have learned my lesson, Your Honor, and I would like to go home and be with my kids. I love them and support them financially, and would love. I've been here over 400 days, Your Honor, and what I did was while I was here, I signed up for GED, and I just want to go home and take care of my
You signed up for what?
GED.
All right, so here's my question. I read the police report. Why did you hit her?
Allegedly,
Well, no, I mean, I read the stipulations, and according to the stipulations, what it says is I spoke with the victim who stated that the suspect, that's you, had struck her
Yes, ma'am.
earlier in the day. The victim stated that the suspect took their daughter's phone. Victim stated that when she attempted to get the phone back, the suspect struck her in the right side of the head one time with his hand. Victim had 2 visible bumps near the right temple. So, explain.
I have to be stressed out or going through something, Your Honor.
So, is this the first time you've ever hit her?
Yes, ma'am.
All right, and what is this violation of protective order about?
I can't be with her. Is that?
No. Yes. So let me ask everyone, the violation of protective order, is that offense alleged to have been committed before or after this incident? Right. So it appears that you have anger issues. So what were you going through that caused you to hit someone that I'm assuming you love?
Probably have to been, probably alcohol was involved, Your Honor.
Mhm.
And, I don't drink no more. I don't smoke. I don't drink. I don't even smoke cigarettes no more, Your Honor. But my, spare time, all I do is read the Bible and learn the good gospel of the word.
All right. This is what the court is going to do. The court is going to find you guilty. The court will give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Capricia, Kaprisha, Lavon Morris. There's a $1,500 fine, time and money to run concurrent, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you. We can go off the record. Here's the thing, you can't hit people that you claim to love. You understand?
Yes, Your Honor. I understand.
All right, good luck to you, all right?
Thank you, Your Honor.
You're welcome. Thank you so much.
Thank you.
Your Honor, if we may, would you consider an application for short probation if we were to follow that?
No.
That'll see where you were at.
Thank you.
Do you need this?
Dominic Nicholson.
The box, bitch.
All right, who's the attorney?
Sorry.
Oh, sorry. Do you need more time to speak with him?
No.
All right, Mr. Nicholson, if you'll come up.
Your Honor, real quick, we do have some judgments that we need to enter, and we do have the fingerprints for the people here.
All right, so if you all will take care of the fingerprint, then I'll see everything else. Thank you. All right, who is Alfonso? Who are you here for?
Ezekiel Neely, Your Honor, restitution hearing.
All right, Ezekiel Neely. All right, is there any proof before we even start the hearing, any proof for the court to consider with regards to restitution?
Mr. Bruneta, you asked for a document demonstrating that the vehicle in question was not released to Mr. Bruneta. I have that document. I gave it to defense counsel for inspection. I may tender it to the court.
All right, are you going to have any objections to the court reviewing that, counsel?
No, Your Honor.
Honor, the document has a notation which says good to sell. Officer Boyd in our office tells me that the good to sell designation has nothing to do with the physical state of the vehicle when it is sold. Rather, it concerns whether there are any liens or holds on the vehicle that would prevent its sale at auction.
All right. So with regards to this vehicle for this complainant, is there an agreement on the amount or no?
On that bill, Your Honor, or on the fair market value of,
All right, so the fees that are listed here, is the $1,169.30, that's the impoundment fee?
Yes, Your Honor.
All right, and then so this shows that he actually did not receive the vehicle back. It shows that it was sold to Platinum Motors Auto Brokers. So I'm assuming, and we're not on the record, I'm just trying to figure out what's going on. So I'm assuming defense, you will stipulate that according to this, it's been sold to a third party.
yes, Your Honor.
And do you believe that Mr. Pruneda didn't receive any money for this sale?
I don't know, Judge. I don't know if he received any money from that sale.
Do you think he received any money from the sale?
I doubt it, but I don't know.
All right, because that's the only other problem, because I didn't know that the vehicle had been sold. I don't think that came out from the last testimony the court heard. It just came out that he never received the vehicle.
That's right.
All right. And according to this, it appears that they sold it. The sale price was $1,200 at auction. Am I reading this correctly? And that the receipt total was $1,352?
Leave you a correct.
Yes, Your Honor.
And let me see. All right, and at his testimony, he said that the Blue Book value was $8,900.
That comports with my recollection, Judge.
Okay. So we do know, so the Kelly Blueback value, putting it at 8,900 and then deducting the 1,300, which I think that should be deducted. And then that would leave a balance of,
Approximately 7,600.
yes.
That's correct, Judge.
So that's what I think the restitution should be for Mr. Pruneda. Is there going to be any objections to the court finding that as the restitution amount?
Not from defense counsel, Judge.
I think it takes into account something that is not in evidence, which is whether Mr. Pruneda was compensated for the sale of his vehicle.
Well, the reason why I'm deducting the 1,300, because they're saying that they sold it for $1,352, which may suggest that's what it's worth. But I'm taking in consideration that it's an auction, and sometimes with auctions, they have a price that if it doesn't go beyond, I mean, if it goes below that, the set price, they won't sell it. I don't know, because I'm not involved in this auction. So I am deducting the 1,352 because he's saying he put his Kelly Blue Book value at 8,900. And I believe he said that was because the vehicle was at, I don't know, I think he said good condition, not excellent condition. I don't know if it was at excellent condition or not, but the defense is agreeing to the payment of the 7,600. Is that what you said, counsel?
Yes, Your Honor.
All right, the $7,600. So if y'all want to go on the record, we can go on the record. But I'm going to put the amount at $7,600.
There is one additional issue for Your Honor. That is
Yes.
for Mr. Tartar.
All right, and he's online.
Yes.
Let's bring him in.
And Your Honor,
Yes.
Mr. Tarter provided to me an explanation of benefits, which I provided to defense counsel.
Mhm.
You then reset this proceeding so that defense counsel could have an opportunity to inspect that document.
All right, and so he put his medical bills, I think, at $1,262.
$82, Your Honor,
All right,
if I read this correctly.
all right, I have my notes, it's $8,262. If it turns out it's $82, we'll figure that out. But he shouldn't be driving while he's zooming, and he is zooming and driving.
Your Honor, if you'll excuse me.
Yes. And we'll go on the record, counsel, once we figured out what all of the amounts are.
Yes, Your Honor.
Hector Garza.
Yes, ma'am.
All right, who is your client?
I understand she may be in the courtroom.
Who's the client for Hector Garza?
It's that Jack, Stephanie.
Shayna Jessame?
Yes, she's not here. So a warrant's going to be issued for her arrest. Do you want to try to contact her?
Judge, she's actually been in contact with my office this afternoon and maybe an hour ago, giving me excuses about why she didn't show up, when as far as telling my staff that she was feeling suicidal. We explained to her what was going to happen, and I got word that she showed up at the courthouse and I was asked to zoom in. So that's why I'm zooming in now.
No, she's not here. If you want to see if you can contact her and see if she is making any plans to come. If she does, if she did admit herself, then of course, you know, the court will take that in consideration.
All right, I'm going to mute myself here, Judge, and I'm going to try to call her one time and see if I can find her again.
All right, thank you. So
Yes, ma'am.
on Mr. Tarter, what medical information do you have with regards to his bills?
The explanation of benefits in his testimony, Your Honor, that he sustained injury, that he was treated for that injury, that the amount billed to him was $8,282, that it was not covered by insurance.
All right, do we have the billing?
Yes, Your Honor, I have it.
If I could see. All right, so with regards to this counsel, first of all, do you believe this is associated with this offense? It appears to be that it's on close to the same date of the alleged offense.
Mr. Tarter is available. You can ask him directly, Your Honor.
Oh, well, before we go into asking him if the defense is in agreement with it.
I agree, Judge.
All right, so he agrees that this is the amount. Now the question is, defense, do you agree that he hasn't received any payment towards that amount through his insurance?
Well, Judge, I don't know. I'd like to ask him about it
Okay.
briefly.
All right, so we'll do that. So, Mr. Tarter, I'm gonna call the case, and what is going to be asked of you is concerning your insurance. Could you unmute for me, please? Court is calling 2024 CR 3316 State versus Ezekiel Neely. Can I have parties announced for the record for the state?
Andrew Harris, Settlement.
Defense?
Good afternoon, Judge. Alfonso Cabañas for Ezekiel Neely.
And are you Ezekiel Neely?
Yes, ma'am.
All right, we have by Zoom, James Tarter. And we're waiting for him to unmute.
There we go. Okay. Yes,
All
ma'am.
right, and if you'll show, okay, thank you. There's your video. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? I'm sorry?
I do, Your Honor. Yes, ma'am.
All right, you can lower your hand, state your name for the record.
James Kirkland Tarter.
All right, which party would like to ask questions?
believe Mr. Cabaña said this.
Mr. Charter, good afternoon. I'm going to ask you some questions regarding your explanation of benefits document that you submitted to the prosecutor's office.
Yes, sir.
Do you have that in front of you?
I do not.
Okay, well. To the
I
best of
haven't,
your
I haven't,
What's that?
I do have an image that I could pull up.
If you can, please, hopefully you're not driving, but if you can, that would help out the court.
All right, are you driving, sir?
No, ma'am. No, ma'am. I am in the passenger seat.
All right, thank you. All right, I don't know if your wife has somewhere that she needs to be that is an emergency, but if you all could pull over, that would help because you're hitting dead spots. So you're going in and out for the Zoom.
Understood. Bear with me just one moment. We will.
Thank you. And so probation, the agreed amount of restitution to Prenata is $7,600. Is that correct, defense?
It is, Your Honor.
State, is that correct?
Yes, Your Honor.
All right. It's Pruneda. First name is Arnulfo, Arnulfo. And the person on the screen now is James Tartar, Tartar.
E.R., Your Honor.
Oh, ER, Tarter.
That's correct. We're pulling in now. We just one moment.
All right, thank you. It just makes it easier if you're not hitting dead spots for the court to hear.
Of course.
Governor Hector Garza have an update.
Just one moment, because we're in the middle of, have you all pulled over yet?
Yes, ma'am. We're parking right now. Okay. We are stationary.
All right, thank you. Defense, you may proceed.
Thank you, Judge. Mr. Charter, if you have the image of the explanation of benefits, I'd ask you to take a look at it, please.
Yes, sir.
So we see that this is an explanation for services you received on November 4th, 2023, correct?
Yes, sir.
Okay. And this document says that this is not a bill. This is just an explanation of the benefits, correct?
Yes, sir.
Did you submit an itemized bill of services that you received during your visit to the Baptist Hospital on November 4th, 2023?
It was automatically submitted by the hospital, and this came back from my insurance company saying that it was not, they called it ineligible charges.
Okay, no, I understand that, but do you have an itemized bill, an itemized list of the services you received that amounted to this $8,282?
Not at this time. I'm sure I can get one.
Okay. If you take a look at the middle of this page, under the column labeled code, there's a number that's 461. Do you see it?
Yes, sir.
Okay. And then if you go a little bit further down, the 461 explanation by your insurance provider states that it's not that these charges were ineligible to be paid. The explanation is that the claims you filed, these particular claims were in excess of the amount of claims you're allowed in the 12-month period prior to this, correct?
I'm not exactly sure. I believe it's because it went to their insurance first for them to try to collect payment.
I'm gonna read it to you verbatim, and if you have it, let me know if I'm misreading it. But code 461 states, as stated in the claim filing provision within your summary plan description, claims filed in excess of 12-month filing period are denied. That's what it states, correct?
Yes, sir. I see that, and I'm not sure
So it doesn't, and if you could ask your wife, Mr. Charter, we're hearing her telling you things as you're testifying. If you could just ask her to remain quiet and make it easier for us to know what you're saying.
Yes,
Okay?
sir.
So what this document is saying is that these charges, it's not that they were ineligible because of the type of incident that occurred. These are just ineligible because you filed claims in excess of the amount you're allowed under your insurance, correct?
I'm not sure. It's saying in excess of the 12-month filing period, but I know it was filed right away.
I
So
get it.
don't really understand. Yeah.
Yeah, I know it was filed right away. I understand. I'm just telling you, because again, this document that I'm reading, this is just an explanation. And this is telling you, the recipient, that the reason why these charges were not paid by your insurance, it's not because they weren't covered. It's because you have filed, according to this document, more claims than you're allowed to under your current insurance plan.
Objection, Your Honor, speculation.
That'll be overruled.
And again, and that's just, if you look at code 461 and the explanation, that's just what it's stating verbatim, correct?
Yes, sir. That is what it's stating. I
All right.
feel like I could get some clarification from my insurance company, but I wouldn't have incurred these charges in the first place were it not for the accident. That's my point.
And that's what we're trying to find out. What type of services you received, an itemized description of what they were, to see what you received because of the accident and what you received because of other medical circumstances you may have had on November 4, 2023. And if you could have that to the prosecutor's office, Mr. Charter, I think it'd be very helpful to determine the amount.
Okay, so I need an itemized bill from that visit.
Yes, sir.
Okay, understood.
Thank you, Mr. Charter.
Yes, sir.
All right, any questions?
Mr. Tarter, you have
Yes, sir.
sustained injury as a result of a motor vehicle collision caused by Ezekiel Neely, correct?
Yes, sir.
And the total amount billed to you for medical services as a result of that collision was $8,282, correct?
Yes, sir.
And you have not been compensated by your insurance company or any other entity for the financial loss that you incurred as a result of the injuries that you sustained because of Mr. Neely, correct?
Yes, sir. That's correct.
Nothing further.
Anything else?
Nothing further from defense judge.
All right, so Mr. Charter, let me explain to you, and both sides can correct me if I'm wrong. I believe that both sides agree that you were injured. The only question is, what is the amount of restitution? So the document that was given to the state, the amount of restitution is just a blanket restitution. It doesn't say specifically what it's for. So what I can tell you, one, you will not need to come back as a witness. The only documentation the court will need is an itemized list of what it was for. And that's to make sure so that the defense or Mr. Neely will know it's specifically for this and not something else that's just thrown in. Do you understand?
Yes, ma'am.
I don't think that you would throw something else in there that should not be in there, but it's just so that everyone can have it and so that I'll be able to make an order and be assured that my order is a correct one. So you will receive a restitution amount. It's just that the defense is requesting that it be an itemized amount. If for some reason the medical facility that you went to said they're not going to give you an itemized amount, just let the state know and you will receive restitution. It'll just then be for me to make a decision on whether or not it's the full $8,282 or not. Do you understand?
Yes, ma'am.
All right, so whenever you can get that, if you'll turn that over to the state, And defense, I'm going to leave this restitution matter open with regards to Mr. Tartar.
Yes, Your Honor.
I'm not going to close it and say that you can't get any restitution because you didn't turn your information in on time. I know how hospitals are and how it is difficult to get information. So just let us know when you can have that available. What I'll do, so we won't lose track of this, I'm going to reset this for 60 days. But if you have it sooner than that, we'll take care of it sooner than that. Do you have any questions?
No, ma'am. Thank you very much.
All right, thank you so much for your patience. All right, so we're gonna come back on April 7th and
I apologize for interrupting. If I receive that information from Mr. Tartar and provide it to defense counsel, can we approach in advance of the April 7th date, since we will not need
Yes.
Mr. Tartar as a witness?
yes. And Mr. Tartar, if you still would like to appear by Zoom, you can still appear by Zoom on that date. So as soon as
Okay.
they receive that information, we'll take care of it, all right?
Yes, ma'am. Thank you.
Thank you. The weather still looks beautiful from your vehicle, so I'm hoping it's still great.
It absolutely is.
All right, you
Thank you.
guys have a great time. Thank you so much.
Thank you. Bye-bye.
All right, so the only restitution amount that remains open is for Mr. Tartar. Is that correct?
Yes, Your Honor.
All right, so we'll recall it for April 7th. And if you all have the information before then, just let the court know.
Yes, Your Honor.
And if we have it before then and your client wants to appear by Zoom, he can appear by Zoom as well.
Thank you, Judge.
All right, thank you.
Are we excused, Your Honor?
Yes.
Fine.
All right, thank you. Thank you for dressing appropriately for court.
Thank you.
All right, Hector. What
Your Honor.
update do you have on your client?
Your Honor, I called and then eventually she called me back. Apparently, whoever it is that may have shown up there this afternoon was not her. She now claims to still be at her home. I explained to her the situation, that if she really was at the courthouse, she needed to go back. And the court would take that in consideration, otherwise a warrant would be issued. She then told me that she could not make it back. That was
All
the
right,
end of the call.
And what I will
This-
tell you is I called the docket and she never responded.
Right, now, I know she wasn't there this morning. But I was notified that apparently somebody went back or was there today, this afternoon. I'm not sure if I misunderstood that then.
No, no one ever came. No one by the name of Shayna Nicole Jessame. All right, court is
Okay,
calling
my-
Oh, no problem. Court is calling 2024 CR 011264 State of Texas versus Shanae Nicole Jessame. Could I have parties announced for the record for the state, for the defense?
Hector Garza Jr.
All right, this hearing was scheduled at 9 a.m. It is now 3:18 p.m. Your client has not made an appearance and your client did not make an appearance this morning. Deputy Laura, did you make an announcement for the defendant?
Yes, Your Honor, I did. She is not in the hallway.
All right, state your request.
Forfeit the bond, issue a warrant, Judge.
All right, what I'll do is, and I'll note for the record, that what I will do is I will issue a judge's warrant and I will remand her without bond. If she makes an appearance, the court will reconsider.
Yes, ma'am. Now, I will let the court know, Judge, she claims that she was taking the bus and would be there sometime today. If she does show up, I'm about 6-7 minute drive from downtown. I can come down and show up if she does show up, or I can jump back on Zoom if the court
If she
feels that's
shows up,
necessary.
you can appear back on Zoom.
Okay, thank you.
You're welcome.
Are we excused, Judge?
Yes.
Thank you.
Maybe excuse you.
Yes.
Thank you.
Yeah. Judge, can I approach?
Yes. There's that. Hello.
Hi. So for Mr. Maldonado, Michael Sawyer is his attorney.
Yes.
There has been no contact within the whole year. I think in March, they're coming up on a year from the offense date for this case.
Okay.
There's been no contact. Stephanie's outside right now trying to see if Mr. Cabanas will take it over
Sure.
and we'll make the change.
All right.
And
thank you.
hopefully Mr. Cabanas can at least talk to him today
Okay.
and do the reset, but
All
we'll
right.
see.
All right. Thank you so much. Good seeing you.
Oh, you too, Judge.
All right. Who's here on Elon Gonzalez?
Present, Judge.
All right, Mr. Gonzalez, if you'll come down. Hello. So what is happening with Mr. Gonzalez?
Your Honor, I've had an opportunity to confer with the state. The state has offered to allow us to apply for the pretrial diversion
Okay.
program. And so I've discussed that with Mr. Gonzalez and what all's involved. He's in agreement to do that. And so I think what we need to do is get on the website and pull down the application and get that done and completed. I'll get Mr. Gonzalez's email and all his good information so that we can get that moving
All right,
forward.
Norm, I need a PTD date.
I can do March 17th. That's okay.
You want the 17th? That's not really 30 days, but. All right, March 17th.
That's Gideon Day.
All right, so that's PTD. And then the reason why you're in custody is because your bondsman got off your bond. So counsel, I don't know if you want to call the bondsman and see if they want to restore his bond.
Who was the bondsman, Judge?
They'll be able to tell you.
Okay, I'll check in the back too.
Oh, let me tell you, actually, it's still attached. Fernando Rover. It's available bail bond. They're saying that you have not contacted them. So,
All right, Judge, I'll see if I can raise them and see what we can do. If for whatever reason they are insisting on staying off the bond, let me confirm with the state and maybe we can
Sure,
go to
you-
agreement to.
yes, you want to
reinstate
call
another
them
bond.
right now and
We
see?
can do that.
All right,
Absolutely. Okay, Judge.
all
Thank
right.
you.
Sure. Who's here on Christopher Floyd Cameron? All right, who is his attorney? All right, oh, you all just put this up. Okay. Because before there was another Cameron. Come down, sir.
Just walk over there, Judge. They're still in the jury trial.
All right, thank you. All right, so we do have the correct person, Christopher Floyd Cameron.
That is an alias. My name is actually Matthew William Brown, but the Christopher Cameron is the right alias though.
Okay. All right. Norma, you want to recall this for next week sometime? Ah, okay, well, calling in 2 weeks.
I can do the 27th.
All right, we'll bring you back on February 27th. Your attorneys in jury trial can't be in two places at the same time. If they finish early and they want to have you brought back over earlier, we'll have you brought back over earlier.
Today or?
Oh, not today.
All right,
Yeah.
yes.
All right, thank you so much for your patience. All right, on Ruben Maldonado, that's going to be Alfonso Cabanas. Elon Gonzalez, that's done, correct? Leo Kantu, completed. Christopher Cameron, that's just done. Lorenzo Gonzalez, done. Allison Settle, completed. Jovan, completed. Davis, completed. Robert Castillo, that was completed, correct? All right, thank you. Nicole Nutter completed. All right, so the only cases we should have left, which I don't know why I have, so I still have Nicholas Lee Cameron. Who's his attorney?
Give me 1 second, Judge, let me look.
I have no idea. As my mom would say, I'm the one-eyed reindeer. I have no idea.
Only for one camera.
And on this one, I don't know why I have it. It was heard on February 3rd. And it was referred to the magistrate's court for competency.
Oh, no. No, the doc, unless they pulled the wrong camera.
Okay. You know, we should have a day where all the Camerons are present.
Sorry, that's almost like it was.
That's okay.
Janet rubbing.
That's okay.
We're in training.
Oh, okay, it happens. Yes. Yes.
This through email. He's at the site release today, but he did say, I asked him if he had any objections to the plea bargain or a transcript of the plea bargain being disclosed, and he said no objection.
Okay.
So at least we have an answer for that. I just didn't know if you want to have Joanna Reyes here. I mean, because that's a whole different episode. I mean, since it is hers. So, but he's saying he doesn't object to it. And he said he didn't feel it was supposed to be under seal. And he's the attorney for it.
Well,
It's gonna be disclosed no matter what at some point.
I mean, it's gonna be
Yeah.
disclosed,
Yeah.
but see if he can get in touch with her.
Mhm.
And is she in the prison or?
No, she's on bond. She's doing really well, actually.
All
So,
right, if we can just set for her to come in court and they can put it on the record that he's discussed it with her and she has no objections. I know it's discoverable, but
Mhm.
it's under seal.
Okay.
All right. And then I don't know if you all want to look at this. And then why do I have Connie Seawall up here?
Oh, that one was.
Oh, sorry. Jason. This is either family violence or criminal trial division as well.
Okay.
And then are you already on Nicholson?
Yes, Your Honor.
Oh, well, we're not on the record yet, but just give me a moment. All right, we're going to go on the record. And I believe the cause number is 2022 CR 11860. Is that correct?
Yes, Your Honor.
State of Texas versus Dominique Nicholson. Do I have parties announced for the record for the state?
Ashley Jones.
Ryan Ephraim for Mr. Nicholson.
And are you Mr. Nicholson?
Yes, ma'am.
All right, you had a jury trial. And the jury found you guilty of count 1 of aggravated assault with a deadly weapon.
Yes, ma'am.
And they found you guilty of count 2 of unlawful possession of a firearm as charged in count 2. And you elected to come to the court for punishment. Are both parties ready to proceed with this phase of the trial, state
Yes, Your Honor.
defense?
Yes.
All right, state, if you would read out the enhancements.
Yes, Your Honor. The state did file 2 enhancements. To the Honorable Judge of Said Court, now comes Judge Gonzalez, Criminal District Attorney of Bergen County, Texas, by and through the undersigned assistant.
You may want to slow down.
Sorry. And just so I'm aware, Judge, do you want me just to read the enhancement paragraphs, or would you like to read the entire motion?
Just the enhancement paragraphs in state, defense, do you stipulate that you are in receipt of the
Yes,
enhancement allegations?
I am acknowledging and stipulate I have received the notice, yes.
All right.
So then I'll just read the enhancements. For count 1, before the commission of the alleged offense in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996, and cause number 94 CR 5960 in the 187th District Court in Bergen County, Texas, the defendant was convicted of the felony of aggravated robbery with a deadly weapon, the Zig gun. And before the commission of the primary offense and after the conviction in cause number 94 CR 5960 was final, the defendant committed the felony of assault, family violence enhanced, and was convicted on the 29th day of January 2013 in cause number D-1-DC-12-904040 in the 427th District Court in Travis County, Texas. For count 2, the state is alleging that the defendant is a repeat offender, and so before the commission of the offense alleged in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 in cause number 94 CR 5960 in the 187th District Court in Bergen County, Texas. The defendant was convicted of the felony of aggravated robbery, deadly weapon, the Zig gun.
All right. With regards to the enhancements in count 1, both enhancements, how do you plead? True or not true?
Not true.
And with regards to the enhancements as read for count 2, how do you plead?
Not true.
All right. Are there any opening statements from either side?
No, with the state will waive opening.
Waive opening.
All right, state, you may call your first witness.
Preliminarily, the state, that Your Honor, the state would like to offer and admit all testimony and evidence that was heard in the guilt innocence phase of trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well
Yes,
from the
Your Honor.
prior testimony.
And all the exhibits as well.
Yes.
Okay, then the state would also offer state's exhibit A into evidence, pending any objection from defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant and hearsay.
All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that state's exhibit A is a self-authenticating document. However, with regards to whether or not this is connected to this defendant, then that objection will be sustained.
And Your Honor, If the state could respond, the state would respond that that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating. But what the part of her objection that I'm sustaining is that State's Exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to somehow tie this document to this defendant. And excuse me, off the record for a moment, could somebody print me out the state's motion for enhancements just so that I can have it? Because I just want to. Oh, thank you.
Yes.
Yes. All right, so so far the objections to State's Exhibit A will be sustained unless foundation is laid as far as connecting
Yes,
the
Your Honor.
defendant with that document.
All its first witness.
All right.
They will call you Valdez.
All right, Valdez. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Mia Valdez.
All right, state.
Ms. Valdez, could you please tell the court what your area of expertise is?
I'm a fingerprint examiner for the Bergen County Sheriff's Office.
And do you have any, you possess any certifications?
Yes, I have a certification in classifying fingerprints as well as identification of fingerprints.
Please explain what those include.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about fingerprints specifically. What is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found two different people to have the same set of fingerprints?
No, not to my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts. And we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our Henry classification that classifies the specific characteristics of the fingerprint.
Now, if that is your way of doing it, is that the standard way?
That's the standard.
That's the what way?
The standard.
And again, for the record, we could just allow me to be found. Well, any of what's been now pre-marked states exhibit A for identification purposes and states exhibit B for identification purposes. Do you recognize those two documents?
Oh, yes, sir.
The story states exhibit A that's in your right hand. What is that document, please?
The Declaration of Sarah Wright. Is this?
If you want to have time to review the whole thing, you can go ahead.
Yes, sir. If you could please review. This is a judgment, sir.
How many judgments are in that package?
Well, there's 3, sir. I go by this. I'm sorry, there's 2.
When I'm looking at six exhibit A, what is that?
This is the judgment.
In both of those judgments that you have in your hand is the name of the arrested person.
on both judgments?
Yes, sir.
Is the date of birth of the arrested person on both judgments?
Yes, sir.
If you could please move to the documents in your hand, exhibit B, do you recognize that?
Yes, sir.
What is that?
This is a fingerprint card, or also known as an ink card,
How do you know that's?
because this is what we use to fingerprint every individual that is brought into the jail.
Okay, do you know who took the individual's prints on that card?
Yes,
And who is that?
that is myself.
And how do you know that it's the same?
I'm sorry?
Strike that question. You testified that you were the one that took those fingerprints, correct?
Correct.
Have those, since you've taken them, been changed or altered in any way?
No, sir, not to my knowledge.
Now, have you had time to compare the prints that's in the judgment, this is an A, to the prints that's in Exhibit B?
Yes, sir.
And what was the conclusion of your review?
The conclusion that is that both of the fingerprints did match.
That the single prints for both judgments?
Correct.
And that matches what's in State Exhibit B?
Correct.
Yeah. When you compared the fingerprints that's in State Exhibit B to what's in State Exhibit A, did you use the same technique that you testified to earlier?
Yes, sir.
Could you please state what the name and date of birth is for State Exhibit A and B of that individual?
So it's gonna be Nicholson Dominic Demetrius, date of birth 6/23/77.
Is that for both documents?
That is correct.
The summary say would offer State Exhibit A and B into evidence.
May I have a chance to?
Yes.
Can you take the witness on board diary?
Yes.
Okay. I may be a little confused. This exhibit B, when were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay, and so there's some other prints in the packet, right?
Correct. They're on the back of it.
Okay, but you were not saying you took those.
No, I didn't.
Okay, so you don't know my client, right?
No.
So you can say that the prints match. But, and you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken originally, right?
No, ma'am.
And so you can't say, you didn't witness that, who the person was who gave the prints.
Correct.
I would object to relevance and lack of affirmative link to my client.
All right. And so is the testimony,
I'm sorry.
was it established who these prints and State's Exhibit B were taken from?
I'm sorry, Judge?
Was it established who the prints were taken from in State's Exhibit B?
Yes.
She did testify as to the date of birth, but she talking about that individual today.
What individual? Do you want to, yes.
Ms. Valdez, you testified that you took the fingerprint States of the B today, correct?
Correct.
Do you see the person in the photo that you took those fingerprints from?
Yes, sir.
Could you please point to that person, identify him by an article of photo?
Will be the gentleman in the red.
You represent the record reflect that this is identified the person that you took the fingerprints from in States Exhibit B.
All right. Defense, any objection with regards to State's Exhibit A and B?
I re-urge the same objections, Your Honor. She has no knowledge of the person who gave the original print.
All right, those objections will be overruled. States Exhibit A and B are admitted over defense counsel's objection. Yes, please. All right, state, any other witnesses?
Your Honor, the state does not have any other witnesses and the state will rest.
And I'm so sorry, defense, did you have any, I know you had taken the witness on voir dire. Do you have any questions for the witness?
Well, just, do you know Mr. Nicholson? No. So the best that you can say is that the prints match, correct? Correct. But, you cannot say who exactly the person was that gave the prints originally, correct? Correct. And you said you use a 12-point ridge identifier, right? Correct. But there's actually like hundreds of ridges on a finger?
I wouldn't say hundreds, but there are multiple.
Well, more than 100?
No,
More than 50?
it's a possibility.
Okay. So the comparison is just to a fraction of the points or ridges, correct?
Correct.
I have nothing further, Your Honor.
All right, any further questions from the state? All right, is this witness excused?
Yes.
All right, thank you so much. You may be excused. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes.
All right. As previously stated, the court is finding the enhancements true. And the court is finding the enhancements true that were read into the record for count 1, and also the enhancements true that were read into the record for count 2. The court will hear argument with regards to sentencing. Mr. Nicholson, you are not eligible for probation from the court. All right.
Yes, Your Honor. The state would like the court to consider states exhibits 39 and 40, which was entered in the guilt phase of trial. That's going to be the judgment from Austin for the conviction of assault enhanced. And additionally, the fingerprint part that was linked to that judgment in the guilt phase of trial. Your Honor, this defendant does have a very lengthy and violent criminal history. In 1996, he was sentenced to 20 years for aggravated robbery. That's going to be cause number ending in 60 that we entered in today. He was additionally sentenced for burglary of a habitation on that same day. That's going to be cause number ending in 59 that was entered into evidence today as part of State's Exhibit B. State's Exhibit A. Your Honor, he was sentenced in 1996 to 20 years in the Texas Department of Corrections for those crimes. When he was released, it was not very much longer until 2013 that he committed the offense in State's Exhibit 39 for assault enhanced, where he was convicted and sentenced to 6 years. So in 2019, after their 5 years are done, it took him only 3 years to commit this offense, this violent offense, where he shot at an unarmed Uber driver who just happened to be picking up his stepdaughter so that she could go to work. Thankfully, nobody was hurt in this offense, but that's just luck, Your Honor. The capacity for this defendant to hurt people in this community and to hurt his family is shown by the criminal history, and the state is asking that the court sentence the defendant to no less than 40 years on count 1 and no less than 20 years on count 2.
All right, so here's the court's question. And I know that you still have your chance for argument, but I'm reviewing the state's notice of intent to use the 2 priors.
Yes, sir.
And the judgment that's been given to the court in State's Exhibit number A, that judgment is for 94 CR 5960, which you have notice of.
Yes.
And then I have another judgment for 94 CR 5959.
Yes, sir. That is not part of the enhancement, that is just part of his criminal history, and that was provided to defense via e-discovery.
No, what I'm saying is if there is a judgment for D1, DC 12, that one,
Yes, Your Honor.
the court is not in receipt of that.
Your Honor, and that was part of the evidence that was entered in at trial.
All right, if we could have that given to the court, please.
Yes, Your Honor.
Cindy, do you have that one?
I would have turned it in already.
Okay.
No, I may have it in my, let me go check in my office.
All right, I just want to make sure that the numbers are matching up.
Yes, Your Honor.
Let me just check.
All right, thank you.
Recall.
Yes. All right, if y'all want to have a seat, I just need to get that document so I can look at it. That sounds like fun. All right, Kevin Owens. Hello. Hello, how are you doing today?
Good, considering, you know.
All right, my understanding is that you're here, but you're here on something that's off docket.
Yes, sorry.
Yes.
I'm a little nervous, so I'll speak slow and keep it simple. I think Hank Wilkins lied to the court about a material fact. More than just one lie.
All right, let me ask you this. Is this something that's related to your trial?
Well, I think,
because if it's something that's related to your trial, I did not hear your jury trial.
oh, yeah, no, not about that specifically, but before, including parts that you had heard and also parts that you hadn't.
Judge, I'm sorry to interrupt you, Mr. Owens, but it's just concerning because I don't know if this is true or not. This case may be on appeal, is that correct?
Well, I mean, it is on appeal.
Okay, I just want to
Thank you.
forewarn the court and Mr. Owens that anything said here possibly could be used for that purpose.
All right. So, Mr. Owens, I didn't hear your jury trial. The person who had heard that would be Judge Angelini. So if there's something with regards to that, you'll need to have Judge Angelini hear that, because there may be things that you're saying I have no knowledge of because I'm not the person who heard the jury trial.
Okay, some parts you had heard. I'm sorry, the court. Judge Boyd, as you know, on the court had heard. One part was heard by, I believe, Associate Judge Kevin O'Connell, who, when he was in the impact court, like kind of a substitute. Yeah. And I mean, I don't want to be here, but I feel somewhat compelled, some personally implied, or personally, you know, a duty to the community, I feel. And so Mr. Wilkins is as part of his job is supposed to seek justice for the community. And I think it's a pretty good guess that the court doesn't want officers of the court to lie to the court about material facts. So I'm here because I think the court wants to know. And I don't do this all the time. I don't really know what I'm doing, but totally aside from directly the case, that's, you know, my allegation or complaint. And so I don't know how we want to do this. But.
All right. Well, I thank you for voicing your thoughts to me. Of course, the court always wants people to feel as though they can come to court, but the appropriate person to discuss that with, if you have a motion, would be Judge Angelini. So, Ms. Ferguson, can you see when Judge Angelini is available? Right, so she's going to call and find out when Judge Angelini is available. And if he's in the court, he will be able to hear whatever you wish to have placed on the record.
If I may?
Yes.
I have a link to a video on the court's YouTube
All
channel.
right, so here's the thing. All right, I want you to hear what I'm saying and internalize what I'm saying. You will need to have Judge Angelini hear that. All right.
Okay.
It's not within my purview to hear it because I don't know what happened at the jury trial.
Okay.
Now, what I can tell you is the way jury trials work is that witnesses are called, witnesses testify, the state will question those witnesses, the defense counsel will question those witnesses. Now, if later people feel as though some witness was dishonest, that's something completely different than saying that someone was being dishonest. You understand?
Yes.
All right. Thank you.
Just, I mean, we could like go to the tape on the YouTube
Mhm.
channel.
Yeah.
But okay, I hear what you're saying, and like, I guess I don't know how to contact Judge Angeline personally.
Oh, we're gonna
However-
find out when he's gonna be here and then you can have a hearing with
Okay,
him.
fair, yeah, because I don't know that.
Okay,
Okay.
I don't know. Just tell him, Mr. Owens would like to speak to him. So whenever he is here, in the building, we can let Mr. Owens know and then you can just go present that to Judge Angelini.
Okay, and I would have asked my appointed counsel to do this for me, but it doesn't seem to me like this is like clearly in his, role.
All right. So what will end up happening is if you'll just remain in the courtroom, we will let you know when Judge Angelini will be here and where he will be, and then you can voice that to him.
Okay.
All right. Thank you so much.
Judge, on this one. Well, this is family violence and it looks like an application for shock probation, but it doesn't. It actually, if you look down, it looks like it's a whole motions and everything. It's still pending. And then this one right here. I think it's an order for removal and of the I believe the work program.
Yes, and it's because he has a
And I-
pending hold.
Yeah, so.
So I figure I would remove for transfer.
Mhm.
And then once he's back in Bear County, the
Yeah.
GPS will be
Yeah, that'd be-
reinstated. Okay, all right, thank you. All right, do you all have the document?
Yes, John, I believe it was State's Exhibit 39 that you're asking for.
All right.
Here we go.
Oh, Tuesday he will be at the courthouse.
Yes.
Do you know where he will be?
He said he'll come here. Because he's gonna be in Belgium.
Okay.
So he said he'll just come here, just do whatever he needs to.
All right, thank you. All right, we're back on the record in 2022 CR 11860. The court is in receipt of State's Exhibit number 39, which was admitted into evidence during the trial. And the court requested it so that the court could review the cause number that's in that document with the cause number that is in the state's motion to enhance. So if everyone will just give me a moment to review that. All right, the court is in receipt of it. All right, defense?
Thank you, Judge. I know that we've heard about his criminal history and the seriousness of it. I did want to offer some context to that, which starts with the fact that the first offense that for which he did the 20 years, he was actually age 16 when that happened. And he was certified as an adult and sentenced, and he ended up doing most of the time. He really lost so many of his formative years at doing that time, right? And then he gets released and is having trouble and has continued to have trouble adjusting. And the second case, the family violence assault case, he pled to and he acknowledges, and I'm not saying he doesn't acknowledge the first case, but he does ask, and we do ask the judge to consider how young he was at that time. I have had contact with two of his family members, siblings who were not able to be here today. One was a Mr. Paxton and another is a sister, Samantha Romborg. And if I may, they both relate to me the chaotic and troubled childhood that they had. and how, in spite of what you see here today, that Mr. Nicholson was actually a loving and caring brother.
I'm sorry, do you want those witnesses here?
No, I think we discuss it. I
No
would be-
objections from the state.
Okay.
That their father was a drug addict and all the children in the family suffered tremendously. And that Dominic felt an enormous responsibility to try to provide for his siblings, which led him to make very poor choices to accomplish that goal. But that his actual motivation, I mean, and led him into down a criminal path. Which I guess partly was role modeled by his father, but also his sense of duty and obligation to his siblings and having very limited ability and resources to provide for them, in his overwhelming sense that he should try to provide for them, really hindered his thinking, and obviously has made extremely poor judgments. I know we stand here today, the jury heard the evidence and returned their verdict. But Mr. Nicholson believes that he can return to society and be rehabilitated. This has been a long revolving door in his life that he is very tired of. And so we would ask the court to please sentence him at the minimum range.
All right, state any final closing argument?
Your Honor, the state, I appreciate that Mr. Nicholson was young when he committed the first offenses. However, I think that just speaks to his criminality as prior life. And although the hopes for change are there, according to defense counsel, his actions speak louder than his words. And the court would like, the state would like the court to consider those actions, the harm that he could have caused on October 10th, 2022, and the harm that he has caused throughout his life.
All right. Is there anything you would like to say?
Yes, ma'am.
Here's the thing, if you want to say something, I'll take you under oath and the state will be allowed to question you. I mean, if you want to discuss it more with your attorney.
Life to be over like this, not being able to say it, but I won't say.
No, I mean, we can go off the record. Here's the thing. Once you decide to testify, and I think your defense counsel will tell you, there are certain appellate issues that may or may not be waived. So it's completely up to you. If you want me to hear what you have to say, I will hear it. What I can tell you with regards to my clients, sometimes they will want to speak and I would tell them, your family has already told your story. Are you going to say something different than what your family has said? So the state was very generous in allowing your counsel to make a proffer to the court about your childhood. So, but if you would like to say something, it's only fair because I want to be fair to both sides. You don't get to just say something and then that's it. What will end up happening is I will swear you in, you'll be under oath. And if you just want to speak generally to me, you can speak generally. I'm not going to sustain any objections for narrative because sometimes people just want to tell me what their thoughts are and I will listen to them. But that being said, whatever your thoughts are that you want to make sure that I know about, then the state will be allowed to cross-examine. So if that's what you want to do, then we can do that.
I've seen it. I hope. Thank you.
All right.
I guess I would say I know he feels like he's really in the fight for his life here. And,
No, we're not on the record yet. No,
okay.
we're still off the record. Yeah. All right, so y'all ready to proceed? All right, we're back on the record. Oh, Mr. Nicholson, this is what I want you to know. No matter what offenses people are alleged to have been committed in this court, it could be offenses that people think are the worst of the worst. I still see everybody as a human being. And when I look at them, many a times I see them when they first start school, like first grade. And I always wonder what made this one child turn left instead of going right. Some people have horrible childhoods and they turn out great. They have a horrible childhood and their thing is, I'm not going to be this way. I'm going to be on a straight and narrow because I need to do this and that. Some people can't overcome it. You know, life just beats them down. And sometimes when you watch movies, when we were growing up, we would watch movies and you see these two children and you thinking everything's going to turn out great for them. And there's one pivotal traumatic thing that happens in their life and it gets them off track and they're never able to get it back in. For example, with you, you went to prison, right? People will go to prison and when they get out of prison, they say they're going to do great things. They're not going to get in trouble anymore. They're going to walk the fine line, right? You get out, you say, I'm rehabilitated, and you say, I'm going to get a job. And then when you try to get a job, people look at your history and they say they're not going to give you a job. And so that's one way where society beats you down. And then you keep trying and you keep trying. And then maybe there's a friend who comes along or somebody who comes along and said, hey, here's some easy money. And maybe you have siblings that you're trying to take care of, trying to make sure they don't have to go through what you went through. But at the end of the day, we all got to pay for our offenses, right? Now, do I think that you should get life in prison? No, right? Your minimum is 25 on the first, on count one. It's from 25 up to life in prison and up to a $10,000 fine. All right. This is what the court is going to do. The court is taking in consideration the state's argument about his history, because I have to consider that. But then I'm also taking into consideration what the defense said. And I think everybody would agree for someone to be 16 and to end up being sentenced to 20 years in prison. And I'm assuming he did the 16 when he was at juvenile, but once he became an adult, they sent him to prison with adults. So for a child to end up in prison with adults who have all of their issues, I'm sure they looked at him a certain kind of way. But even though that happens, we can't be in a situation where life has beat us down, so therefore we're going to beat other people down, because then it just becomes a circle. So all of the offenses that you've committed, guess what? That complainant has been traumatized. So there has to be punishment. And you're not eligible for probation. And based upon what I've heard during the trial and based upon what I've heard during this punishment phase, I will not grant you probation, right? Even if you were eligible, because I don't think you're a good candidate for probation. But I also don't think you should spend the rest of your life in prison. All right, so in count one, as previously stated, I'm finding both enhancements true. In count two, I'm finding the enhancement true. In count one, I'm going to sentence you to 30 years in the prison. In count two, I'm going to sentence you to 20 years in the prison. The counts will run concurrently. There's an affirmative finding of deadly weapon in count one, and there's to be no contact with Jayla Satterwhite. Is there anything else with regards to sentencing from state or the defense?
Yeah. Taking into consideration state also has
All right, and the court will order affirmative finding of family violence.
And I assume the court will be giving him credit for all time served.
Yes, and you'll receive credit for any time served that you've been in custody and counsel. If you believe the credit is incorrect, just let the court know. We'll make sure that it's corrected. And for some reason, I do not have the trial court certification. I'm sure you probably filled it out before, but do you mind filling out another one for the court?
Okay. did one.
Yes,
not to do
it's
this.
on the wall. And she is going to give you a document that's entitled Trial Court Certification of Defendant's Rights to Appeal. You do have a right to appeal because this is a jury trial that occurred. Do you understand? All right. Your counsel is court appointed, so what will end up happening if she withdraws from your case, a new attorney will be appointed to handle any appellate issues. Do you understand?
Yes.
All right, because this is an affirmative finding of family violence, and also because these are felony convictions, and you should know by now, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, do you have any questions about anything?
Just, I didn't hear you, I don't know if you were doing it or not, the fines.
No fine.
Thank you.
All right, and state the other case.
Your Honor, at this time, there's no, disposition on that case. At this time, I guess if you would like to set it, and it should be resolved by the next court date.
All right, Norma, if you can recall this for Tuesday.
Sounds good.
All right, here's your document.
Thank you.
You're welcome. We can go off the record. So, Mr. Nicholson, I know it's a lot of time, right? And you have to do half before you're eligible. But guess what? At the end of the day, it's not the end of the world for you, right? You're gonna be older when you are released from prison. There's no ands, ifs, or buts about it. But you can still take this time to try to better yourself while you're at the prison. You can still get degrees. Young people who come into prison, if they're not acting crazy, you can probably give them some advice to help them do better and be better. And you're still alive. You can still pick up the phone, call people. You can still write letters to people. Hopefully people will come visit you at the prison. You can still have that. As long as we're alive and breathing, we have the opportunity to change. You understand?
Yes, ma'am.
So it can still be done. You can still come out and do great things. All right. All right. Good luck to you. We're going to see you back on Tuesday. Okay.
Okay,
All right. Thank you.
thank you.
We're off the,
You're welcome.
off the record.
Yes.
Okay, so just a matter of logistics on the appeal.
Yes.
I'd file a motion for new trial and then wait to file the motion to it, because I'm not on the appellate wheel.
Well, what we can do is we can take that up on Tuesday
Okay.
because you'll still have enough time. 30
Okay.
days will not have
Right, right, right.
expired.
I just want to make sure I get it in the right order,
Yes.
because I think there was a particular order on the motion to withdraw on the file.
Yes.
Okay,
All right. Thank you. We'll see you back on Tuesday.
okay, thank you, Judge.
Thank you. All right. Is there anyone else on the docket? Yes. Yes. Yes.
Yes.
All right. And Norman, so if we stay here till midnight, that's fine with me because I have to teach tonight, so it's fine.
Yes.
Yes. Who do you have?
Yes, Mr. Maldonado, Judge, the MAC notified me, there may be an issue of his representation, so,
Yes.
we're glad with the Public Defender's Office to represent him, Judge.
Okay.
So just being assigned to the case, we respectfully request time to look over discovery to advise client of how to proceed.
All right, Ms. Ferguson, if we can recall Maldonado in 30 days, please. March 18th, is that good for you?
Yes, Your Honor, that is good.
March 18th.
Yes.
All right, once you sign the reset form, you are excused. Thank you so much for your patience.
Thank you, Your Honor.
Thank you. All right, and McLean?
I spoke to the bail bonds over the available bail bonds.
I've already signed it.
Awesome.
Yes.
And so he is out. And so I think we just need to get a reset from Ms. Norma.
All right.
And we'll sign that and come back for the pretrial diversion. I'll get online and fill everything out.
All right, so the pretrial diversion date has already been set. So if Ms. Ferguson, if you'll get him his reset form?
Yes.
I got that one, yes.
Okay.
And you're
We have to find out what's on the
Klein's other case, Garcia, DWI third. We have modified a county court standing blood discovery order for use in the district court. Mr. Garcia is no longer here. However, he was here earlier in the day.
I should get that rolling. And Judge, just so you know, the state has proffered an offer. I'm gonna discuss it with my client. Hopefully we can get a resolution.
Thank you.
I have some questions about a case that is set for trial for next week. Michael Ogden, possessed weapon prohibited place. I have conferred with defense counsel. I informed defense counsel that if the defendant is willing to forfeit the weapon in that case, then the state will dismiss. So the state's question to the court is whether the court will allow the state to tender a dismissal and a motion to forfeit weapon without the presence of the defendant. If so, then it vitiates the defendant's need to appear on Monday unnecessarily. If not,
He'll need to be here.
I suspected that's what you would say, but I told defense counsel that I would ask and report back to him.
Yes, he'll need to be here. All right, thank you. Norma, do we have anyone else on the docket?
We canceled them downstairs.
No, who else do we have?
We had Charles Gold's client. Oh, okay.
Yes.
That was it.
Yep, Charles Gold client. I think that's already been taken care of. So do we have anyone else? Well, happy Friday's Eve, everyone. We have done, I will see you all on Monday, but of course I have to teach class.